Good afternoon, everyone. Welcome to the Planning Skills session today on Electricity Act casework with the DPEA and ECU. My name is Trevor Moffat from the Improvement Service. I'll be facilitating today's session and will be helping out with any technical details. I will now pass over to Simon Hinson, Technical Manager from the ECU, and then I'll let the rest of the presenters introduce themselves. So thank you everyone for joining.
Hi, good afternoon everyone. Really good to see so many people on the call today. As Trevor said, I'm a technical manager at Energy Concerns Unit. I'm currently seconded into the Scottish Government. Prior to my current roles, I worked in local government at Highland Council for a significant number of years, dealing with a substantial amount of Electricity Act applications under both Section 36 and Section 37 and the associated appeals. So happy to be given this presentation today, and I'll pass on to my colleague Carolyn Wilson.
Good afternoon, everybody. My name's Carolyn Wilson. Similarly to Simon, I'm seconded in currently to the Energy Consent Unit, and we've been helping them out for the last 10 months or so with some technical work. My background is as a town planner, similarly to Simon, but it was a long time ago when I worked in local authority, leaving in 2002, and I've been 10 years working in renewables and quite a bit of time working for telecommunications as well over my career. So that's me. I'll hand over to, I think it's Sinead.
It is. Hello, my name is Sinead Lynch and I'm a reporter with the Directorate for Planning and Environmental Appeals, DPEA. I'm a town planner and I've been working with DPEA since 2014. Lots of wind farm experience, both PPAs and Section 36 cases. So today, my colleague Keith and I will be talking to you about public local inquiries. I'll pass over to Keith.
Thank you, Sinead. Good afternoon, everyone. My name is Keith Bray, and I'm also a reporter with the DPEA, probably for the last 8 years or so, and a local authority background before that. And we also have David with us.
Hello, everyone. My name's David Little. I'm one of the Assistant Chief Reporters at DPEA, and I've been working there for the same 11 years that Sinead has. So I'm just going to pass back to Simon.
Super. Thanks, everyone. I'll just go through the agenda briefly that we've got for you this afternoon. So we're just going to set a little bit of context around about decision making and the legislation that we work with. Then we're going to move through how Electricity Act applications are handled by the ECU, what the application processes are, a little bit on planning authority consultation responses, and then other types of applications handled by the ECU as well, before passing on to the DPEA, who's going to cover off the public inquiry process. Then we'll move on to the decision of Scottish ministers and matters post-determination as well. So starting off with context, the impacts of climate change continue to be seen, and decarbonisation of our energy network is critical in reaching net zero. In addition to the need to ensure secure energy supplies is becoming more of a pressing matter, with grid connection reform also needing to be addressed. I think it was in 2023, the onshore wind sector deal was signed, and as part of that, there are a number of commitments that were brought forward, including dealing with Section 36 applications within 12 months if there's no public inquiry, or 24 months if there is a public inquiry, and Section 36C applications to be dealt with within 9 months. And then for priority transmission projects, and there's a specific definition of that, the aim for those is to deal with them within 52 weeks, including if there's a public inquiry required. When an application is submitted, there's a need for applications to be determined efficiently to enable clarity and transparency for communities who may be affected by the projects and who are engaging through the process. And just as I've highlighted on the slide here as well, there's the economic benefits of swift decision making as well, not just swift, but efficient decision making, making sure every consent is dealt with robustly. But it delivers greater certainty for developers and investment decisions as well, to allow projects to move forward to hit those important targets. And lengthy determination timescales can lead to uncertainty in financial modelling, undermine a business case for development due to changes in the supply chain, finance models, and grid connections. But also there's a risk that where there is a longer determination period, that there may be variations brought forward to the application as well, which is a further submission and timescales that need to be considered, which has resource implications for consultees as well as the ECU and DPEA. So just in terms of what types of applications the ECU deal with, so I've got a few pictures on the screen just to kind of demonstrate some of them. Not all in Scotland, I might add, these images, but we've got hydro schemes, we've got pumped hydro schemes as well, we've got battery storage, we've got transmission projects, onshore wind, and then we've got other technologies such as gas power stations and carbon capture units. At ECU, they also deal with necessary way leaves and compulsory purchase orders, and I'll come on to those a little bit later in the presentation. Generally, applications for generating stations of 50 megawatts or more in terms of their generating capacity. While this is currently the threshold for Electricity Act applications for generation, as covered in the Resource and the Planning System consultation last year, work on that threshold is ongoing with the potential view to uplifting that threshold moving forward. The capacity, it's a capacity threshold for Section 36 applications rather than output, as capacity is a clearer and more consistent measure. But there are situations where a project can be consented under town and country planning, under 50 megawatts, but through changes to technology, when it's installed, then it may creep over 50 megawatts. If that's the case, then a Section 36 consent would be required to operate the development. Transmission projects, so they're generally those over 132 kilovolts, but also distribution lines are covered off as well, but they do follow slightly different processes. And just for clarity, Energy Consent Unit only deal with onshore energy infrastructure under the Electricity Act, and the Marine Directorate deal with Section 36 applications for offshore energy developments under the Electricity Act. And anyone can make an application for consent under the Electricity Act, but only transmission operators or holders of a generating license can operate the developments. So just to kind of highlight some of the key legislation that we work with on energy consents. So we've got the Electricity Act, as I've already mentioned, and Section 36 is for the consent required for the construction of generating stations. Then you've got Section 36C, which is for variations of consents under Section 36, and that is again is variation of the generating station or any conditions associated with the Section 36 consent, rather than the deemed planning permission that comes with Section 36 consents. We've got Section 37 of the Act that is related to transmission and distribution for the consent required for overhead lines, and there are some limitations, limited exemptions set out in the 2013 exemption regulations for things that don't need consent under Section 37. We'll come on to those separately if anyone's interested. And then under the Electricity Act, we have two key schedules. So there's Schedule 8, which covers off the procedural requirements for applications to be dealt with under the Electricity Act, and they're supported by the consent regulations. And we've also got Schedule 9 of the Electricity Act, which sets out a pseudo test, I suppose, in terms of how Section 36 applications need to be considered by ministers, but also how they need to be prepared by the licence holder. And we have the EIA regs, which is separate to the town and country planning EIA regs. The bulk of them are the same, but there are some differences to the town and country planning EIA regulations. And as part of that, it's really important. Scoping is a really important stage of the determination of Section 36 and Section 37 applications, because the EIA report, if indeed the development does need EIA, most onshore wind farms do, but not all transmission infrastructure does. But the EIA report must be based upon the scoping opinion, so it's really important to get any response to a scoping opinion if as a planning authorities will always be consulted on those. It's really important to respond to those to ensure that efficient decision making further down the line, and the process isn't required to be delayed by additional environmental information. You've also got the Habitat and Species Regulations 2017, which took over from the Habitat Regulations 1994, which looks at the impact of development or likely significant effects on European protected sites. And you've got Section 57 of the Town and Country Planning Act related to the deemed planning permission that comes with the Section 36 consent when it's granted. We're going to be focusing today on the application process, so from the point that the application is submitted to the point of determination, and then some procedures beyond that. But also pre-application is hugely important to Section 36 and Section 37 proposals. And those who have been following the Planning and Infrastructure Bill going through the UK Parliament at the minute may have noticed some changes to the Electricity Act coming through that, particularly around about consenting in Scotland. The bill is still working its way through UK parliamentary procedures, and then secondary legislation and regulation will be required to be taken through the Scottish Parliament, so we can't cover that in too much detail at this point, given that the Planning and Infrastructure Bill is still fairly early stages. But one thing that we can cover today is round about pre-application guidance for transmission projects that require EIA. New guidance was published just this morning from the Energy Consent Unit to set a level of expectations for transmission operators, and also to highlight when and how communities can get involved in that process. So just moving on to a little bit to how Section 36 and Section 37 applications are handled by the ECU. Sorry, my technology is failing me now. There we go. Okay, so how the ECU is organised. So you have the head of energy consents, and then below that is a head of operational delivery. So they look after the majority of the consenting aspects, but they also work through a lot of the legislation. You've got the head of grid, who looks after the grid teams, and we'll come on to those individual teams in just a wee minute. And then you've currently got the technical managers, which Carolyn and I are currently doing on a job share secondment at the minute. And there's below that, there are a number of separate technology teams, and that's how we're split up. So I know in a number of planning authorities, they have specialist teams for certain types of applications, or it's split up by geography. In Energy Consent Unit, it's all split up via the technologies. So we've got 3 onshore wind teams, each with team leaders, senior case officers, and case managers. We've got a battery energy storage team. We have a new technology and other generations team, so they deal with things like pumped storage, hydro, other hydro schemes, and they deal with things like carbon capture and storage as well. And then there's the applications that come through them as well for oil pipelines. Very few applications for those, if any, to be honest, in recent times. And then we've got the grid team, which is actually split into 2 teams. One dealing with non-EIA, smaller scale Section 37 applications, and other with larger, more complex applications which require EIA. And across the 2 teams, they also deal with way leaves and compulsory purchase orders as well. And then we've got the policy and administration team dealing with reporting, finance, such as fee submissions, and then paying those out to planning authorities under the voluntary agreements. And then they respond to non-project correspondence, such as freedom of information requests, environmental information requests, correspondence from ministers, and then they coordinate with other government departments as well. So in terms of a few stats, so the number of Section 36 applications is increasing year on year, and the number of Section 37 applications had been fairly consistent across time, some of which were getting more complicated in terms of their scale and length, but it is anticipated that there'll be a significant rise in the number of applications coming forward as priority transmission projects, which include those kind of key pieces of infrastructure for transmission, which connect various different generating sources to the grid, but also to allow the major upgrades to get the electricity from where it's generated to where it's needed. Alongside those Section 37 applications, we're anticipating that there will be a large increase in way leave applications to align with the increase in Section 37 applications. But there has been an increase in staff within the ECU to determine the increased workload, and that's resulted in increased determinations in 2025 already. So lots of stats on this screen, but the things to maybe pull out are the number of new applications that are coming in over the last wee while and over the rest of this year. So it's anticipated that in Q2 this year, so March through to June, we'll have a further 18 new applications coming in, a mix of generation and transmission. And that would take us up to a total of 173 applications currently sitting with the Energy Consent Unit, but we're also anticipating that we will have 30 determinations within Q2 alone. Already this year, we've had 43 determinations across the Energy Consent Unit of Section 36 and Section 37 applications. Okay, so moving on to the Electricity Act application process. So much like planning applications, when Section 37 applications come in, they are submitted. So once the full development application has been received, it then goes through an allocation process with an Energy Consent Unit. Like in local authorities, generally the case officer or case manager who's been dealing with it at the pre-application stage will be allocated the application for determination. At that point, it then moves on to a validation check, where the case officer assessing the information within the application, make sure it contains all the necessary information. They do checks against the scoping report, and they do checks against the gate check report as well, in terms of what the applicant was either told to do at scoping or asked to do at the gate check stage. They'll just double check that that's all covered off in terms of validation, and then they'll go back to the case to the applicant if there is anything missing. There isn't any particular validation standards on Electricity Act applications in any great detail like there are for planning applications, but generally that check does pull out if, say, a validation's miss, a visualization's missing, or a document's missing, and things like that. Following validation, that's when the application goes live on the ECU's portal. At that point, the application goes out for public consultation. So for under the EIA regs, that's a minimum of 30 days. Under the consent regs, it's a minimum of 28 days. So the longer of the periods is always the one that is in the public adverts. And at the same time, views are sought from statutory consultees and the and other consultees as well. I appreciate someone asked in advance if we can share a list of the consultees that we use. I'm sure we'll be able to do that, but unable to do it in the kind of chat function today. But happy to pass that out via Trevor following the session. And once the consultation responses start coming in, the ECU case officer, in fact, before that, once the application's in, the ECU case officer starts assessing the application alongside the consultation responses to ascertain the next steps for the application, whether that be further queries back to the applicant in terms of any points of clarification that's arisen either through the case officer's consideration of it or via consultees, starting to negotiate roundabout conditions, and also looking at any matters that needs further input from consultees or any kind of further technical advice from other parties. And what are the things that people will generally see appear on the ECU portal is an advice note from Ironside Farrar, usually related to peat landslide risk on wind farms, for example. So that's an external. It's a company that the ECU have a contract with to review such matters as they come in. And then if the planning authority don't object to the application, then it goes through to the determination stage. However, if there is an objection from the planning authority, then it would be referred to the DPEA, and I'll pass on to colleagues later in the presentation from the DPEA who will cover off that side of it. But in terms of the determination, if all information required to make a determination is available, a recommendation is then made to the Scottish ministers. There are some delegated powers to staff within ECU to deal with matters, but so not all applications go to the minister, but most of them do, particularly if they are controversial. But at least the ministers will be informed of all decisions and asked whether they want to consider them further themselves. And then at that point, if the minister is happy with the recommendation to either grant or approve, then the decision will then be issued. That comes in the form of a decision letter rather than necessarily a decision notice, but that decision letter contains at least 2 annexes. The first annex is the description of development, setting out what is actually getting consent. So much like the front end of a decision notice on a planning application. And then the second annex contains the Section 36 conditions, which are the responsibility of Scottish ministers, and then the deemed planning permission conditions, which are the responsibility of planning authorities to deal with moving forward. So just in terms of those onshore wind sector commitments that I mentioned earlier, I appreciate that highlighted again on this slide. But just wanted to highlight that there is a recognition from the industry that they require to submit quality applications with all the required detail for EIA submitted with the application to reduce the need for additional information through the EIA process. And if they don't submit the sufficient quality of information, then there will be there is an expectation that there will be delays and these timescales won't be met. But as mentioned, proportionate EIA and scoping should help with this. And there's some EIA streamlining guidance, which we'll come on to just very briefly on one of the later slides, which will hopefully assist with things moving forward. So we've got a more proportionate application coming into planning authorities or the ECU, planning authorities and other consultees to look at. Moving on. So in terms of the ECU approach to applications, generally the ECU seeks to negotiate improvements based on the consultation responses. But there's different approaches to how an application is dealt with for different technologies and types of application. By different approaches for different technologies and types of application, what we mean is looking more into the it's like any planning application really. You maybe look into certain aspects more on a battery storage scheme related to localized landscaping schemes, for example, than you would do on a Section 36 wind farm, for example. And to facilitate consistency moving forward, standard conditions have been published earlier this year for Section 36 consents and deemed planning permission. The approach that is intended with that is that it'll be a more efficient process moving forward, so that conditions can be discussed and potentially agreed at a much earlier stage in the process. So the idea being that the applicant submits a set of conditions based on the standard conditions at the outset with their application, and then instead of the planning authority in their response or the consultees in their response having to prepare a set of conditions, they can effectively just respond to the applicant's conditions with their response, with any further conditions that the planning authority or the consultees may consider needs to be attached. We're also doing the same for Section 37 conditions, and they're going to be published in the near future. And just in terms of timescales for consultation responses, on Section 37 applications, there will be no consultation extensions for priority transmission infrastructure applications, and that was communicated out earlier this year. I think it was February this year, to planning authorities. And then on Section 36 applications, beyond that initial 4-month consultation period that you get via regulations, it's likely that consultation extensions for planning authorities would be limited to an additional 4 months maximum if it's required, but only in exceptional circumstances. And we've got guidance on generation and overhead line application processes on the website, and I think Trevor sent out some links this morning to some pieces of guidance on the website for both ECU and for DPEA. So just in terms of planning authority consultation responses, I've touched on the streamlined EIA moving forward. So as part of the onshore wind sector deal, we are producing with the industry guidance on streamlined EIA. So not everything that is in an EIA actually needs to be in an EIA most of the time. The EIA is there to focus on the significant effects of the development, and with that, the streamlined EIA guidance, which should be published by the end of this month. We're just kind of doing some final tweaks to it at the minute. Sets out what is a slightly different approach to scoping EIAs, and that will take time to bed in. There's no doubt about it, both for the industry and for consultees and the ECU. But we're hoping that will make a difference moving forward. And we're also producing some planning authority response guidance as well, highlighting what would be most helpful to the ECU to have in planning authority responses to applications, but also trying to relieve the burden as much as possible from planning authorities, given the timescales involved. So it's given guidance to planning authorities. It's not saying you must follow this, but it's suggesting that if you follow this, hopefully it will lead to less of a resource burden on yourselves moving forward. And as part of that, there's going to be a response template. Some people may remember the old Form B that used to be required to be submitted back with Section 37 responses. Not as complicated and difficult to fill in as that, hopefully, but it's a high-level form. Just asking for some key information. But also in planning authority consultation responses, while I can fully understand, and from my position as a planner in a local authority previously, why SEPA, Nature Scot, Historic Environment Scotland's comments are considered in the planning authority response to an application, just to be rest assured that ministers take into full consideration the responses that come back from consultees, and therefore it's not necessary to cover those matters in detail in the planning authority response. And we've covered the standard conditions already, and I could see things are popping into the chat, and Carolyn's picked up one of the questions on standard conditions already, but it is there to hopefully make the process more efficient for everyone, and that'll feed through to the public inquiry process as well. If there is an objection to an application, it should speed matters up there too. And just to highlight the implications of not returning responses to ECU within the specified timescale. So if the response isn't returned within the timescale that has been agreed with the ECU and the developer, a public inquiry isn't automatically going to be held. So in terms of other applications handled by the ECU, just touch on those briefly. We have necessary way leaves. We'll start with those, and that's a legal mechanism to allow electricity network operators, so transmission and distribution lines, to secure rights to install and retain access overhead or underground on lines where the agreement with the landowner can't be reached. The ECU and DPEA work together on taking those forward under the Electricity Act. But moving on, in the future, applications relating to those transmission priority projects are submitted directly to the DPEA rather than going through the ECU first. The purpose of that is that if there is an objection, the DPEA can deal with that straight away through the process that's in place already. But when making a necessary way leave application to the ECU, the specific requirements that need to be taken forward by the transmission and distribution operators, and that is related to landowner engagement and things like that. Similarly, compulsory purchase order, that is available for transmission and distribution projects as well. However, it can also be used as by license holders, so those generating stations, to allow them to acquire property, land or land rights connected with the carrying on of activities where the license holder is authorised by the generation license to carry on. But it's maybe important to note at this point that not all generation license holders necessarily have compulsory purchase order powers within their generation license. It's something specifically that they have to request from Ofgem when they are applying for their generating license. And a CPO, so what happens with a CPO is it's an order that is made, and a CPO can only be supported where the land rights are deemed absolutely necessary for the public benefit. And that is the same test really that comes with CPO powers for other responsible authorities for compulsory purchase. So people like councils, for example, where they're looking to compulsory purchase land for development, for example. So
thank you very much, Simon. As I said earlier, my name is Sinead Lynch and I'm a reporter with DPEA. Today, my colleague Keith Bray and I will be giving a very short introduction to the public inquiry process and what DPEA actually does in relation to Section 36 and Section 37 applications. What triggers public local inquiry? The standard trigger is an objection from the planning authority which has not been resolved, but other objections can also trigger a public local inquiry. Scottish ministers may decide that a public inquiry is necessary to determine the application, or it may be that issues raised in consultation responses from statutory consultees or others are considered significant enough to trigger a public local inquiry. Once the public local inquiry is triggered, the entire case is passed to DPEA. A reporter, sometimes more than one reporter, and a caseworker are appointed to the case and the parties are notified. At this stage, we do accept new representations, and you may find that new and or additional parties may enter the process at this point. We have quite specific targets for processing inquiries. Our target is 50 weeks from receipt of the Section 36 application from ECU until submission of our report to ministers. And for ASTI and priority transmission projects, it's a 52-week deadline in total. So they're slightly different in that the overall target is different for Section 36 applications, but the total target for ASTIs and transmission projects is 52 weeks. In order to reach those challenging targets and in recognition of the volume of transmission-related projects, including CPOs and necessary way leaves that we know are coming our way in the next number of years, we've recently restructured our internal teams to create dedicated caseworkers and reporters for ASTIs and transmission cases, which will also include CPOs and way leaves. Section 36 cases in DPEA will continue to be allocated to reporters based on their availability. Some statistics for DPEA for the years 2024 and 2025. We received 10 Section 36 wind farm cases. We issued 8 reports, and 5 of those were by the oral inquiry process. We didn't receive any Section 37 transmission cases, but did issue 6 decisions, and all of those were determined by the oral inquiry process. The average time taken by a reporter to complete a Section 36 report is approximately 15 to 20 weeks over that 50-week period, which is at least 50% of a single reporter's available working time in a single year. So it's a considerable resource allocation for DPEA. The substantial volume of transmission cases and associated way leaves and CPOs will be a challenge, but we have put a process in place. We have, as I said, reorganised our structure, and hopefully we will be in a good position to deal with the volume of those cases. The purpose of PLI is to provide Scottish ministers with a report containing reasoned conclusions and conditions on each topic and any areas in dispute. Our reports also contain a recommendation to ministers on whether or not to grant a consent under the Act and deemed planning permission. Following the entire process of the public inquiry, our reports are submitted to ECU initially and then on to Scottish ministers. At the very beginning of the process, once the case is registered with us and the document management procedures, which Keith will talk about, have been gone through, a reporter and a caseworker have been appointed. The initial part of the process will include looking for position statements from the parties. The applicant will have already submitted a position statement to ECU, but we ask for, at this stage in the process, a more detailed statement. We provide templates to the parties. We circulated earlier our template that we send out to applicants and to planning authorities and other parties. The template is very comprehensive. It includes site descriptions, location plans, EIAs, any additional information that's subsequent to the initial EIA submission, any modifications to the scheme. It includes a request for summaries of any proposed mitigation, any proposed monitoring measures, a summary of significant effects, a summary of the supporting information that accompanied the original application, a summary of consultation responses, all other representations, initial views on topics and procedures that the applicant and the planning authority think would be part of any public inquiry process, availability of dates for pre-examination meetings and inquiry and hearing sessions. We do have an abbreviated version of the template, which can be sent to other parties, looking for your response to the applicant's position and also your availability. It is important to use the templates. We use the templates that are submitted by all the parties to inform our initial reading of the case and to prepare. In fact, we use them substantially to prepare for the pre-examination meeting. The process is slightly different for ASTIs and transmission priority projects, and we do have separate guidance which we circulated a link to this morning. Moving to, well, actually, before I leave or position statements, you should, if possible, view them not as a reiteration of your case, but a chance to focus in on your own case and the case you may put at any inquiry process, and to prioritise your own evidence in terms of what witnesses you may call and what evidence you may eventually submit. A pre-examination meeting. We hold pre-examination meetings normally 6 to 8 weeks after we receive a case. All parties who have indicated that they wish to take part in the process are invited to take part. We did send you a link to our code of practice, and it's worth familiarising yourself with that if you are going to be involved in any Section 36 or Section 37 cases. The key difference in our code of practice between what we might do in a standard planning appeal and a Section 36 or Section 37 public inquiry process is that where a dispute occurs, we must resolve these procedural matters by agreement and negotiation. It quite often requires a reporter to issue a ruling on a matter because quite often there is disagreement between the main parties as to how or when we should proceed. The pre-inquiry meeting agenda is quite detailed. We will always circulate a draft so that all parties can comment. You can add or make alternative suggestions. For example, in advance of the meeting, you can make suggestions relating to potential dates or venue inquiries. The agenda will include what our view on the matters in dispute are, what we consider the most appropriate procedure to address those matters. It will also address document management, core and foundation documents, dates for the inquiry, and any site inspections. The inquiry format will be agreed at the pre-inquiry meeting. The pre-inquiry meeting is now almost by default virtual, depending on numbers. Quite often we do hold them in person if the numbers taking part are going to be too unwieldy, but our default position for efficiency is that we will hold them virtually. So quite often there could be a hybrid approach to the inquiry format, subject to agreement with the parties. And by that I mean we may hold some sessions in person, some sessions can then be held virtually where perhaps there aren't as many people taking part. The primary aim of the pre-inquiry meeting is to agree all of the procedural arrangements for the inquiry and to make sure as far as possible that all matters have been resolved before we start proceeding to the inquiry itself. Some thoughts on the virtual process. They can be challenging. There can be broadband reliability issues, and quite often there can be limits to the ability to webcast from particular venues. The numbers may be unwieldy to deal with online. It can also be very difficult for particularly non-professional parties who are taking part in the process to take part in a large inquiry online. The comfort of those taking part, and particularly access to documents. We have found in the virtual process that parties who are working perhaps on a laptop on a single table without multiple screens can have difficulty accessing documents and taking part in the process to their own satisfaction, and perhaps other people's. It is quite difficult. The upside to virtual process is that they can be very efficient. There's a complete lack of travel. They can be non-confrontational. It can sometimes be more comfortable for parties not to be in the same room with others. The format ultimately of the inquiry process will depend on the complexity of the evidence that's before us. For example, technical matters quite often require two professionals and may require an oral process. Landscape and visual matters are often a topic that is dealt with via an inquiry session, and that is mainly because we have opposing professional views, which we need to test in order to reach a reasoned conclusion to inform ministers and to make a recommendation on whether or not consent should or should not be granted. We quite often manage the participation of residents and some community councils through community hearing sessions. Those are slightly different to our normal sessions. We tend to hold them in the evening. They are absolutely non-confrontational, non-adversarial. They generally involve residents explaining to the reporter their position. The reporter will have some questions. The applicant and the planning authority are invited to attend, but it is not an opportunity for cross-examination. They are there normally to answer questions that may arise. Agreeing dates for the inquiry process can be quite difficult, which is quite important in terms of your initial position statement response. If dates can be indicated when you are or are not available at that point, it makes life a lot easier when it comes to the pre-inquiry meeting. There is a very small pool of professionals in the UK and in Scotland who deal with Section 36 and Section 37 cases. And given the number of applications that Simon highlighted earlier in his slide on statistics, you can see that their availability is quite limited. So agreeing dates at the pre-inquiry meeting, or ideally in advance of the pre-inquiry meeting following submission of position statements, can be very, very useful. We start working on dates as soon as we receive the case. As soon as a reporter has read into the documentation, read the position statements, we will make our assumptions on the procedure best suited to the topic in question and work on the basis that we need particular numbers of days in person or virtually, either a hearing or a formal inquiry process to deal with those. Our IT team are very helpful for all involved. They're available to all, not just to us. And their availability is a factor that we take into account in setting dates, particularly if a process, either a hearing or an inquiry, is going to be webcast. I'm now going to pass over to Keith, who will outline some further detail on the DPEA process in relation to public local inquiries. And following Keith's session, we will have a short question and answer session on public local inquiries and DPEA. Thank you.
Okay, thanks, Sinead. I'm going to move on to the different methods that we use to gather evidence during the PLI process. Sinead's touched on a few of them, but I'll expand. For the purpose of this presentation, we've identified 7 methods that a reporter may normally use to test evidence. In all of these, we would like to emphasise that the deadlines that are agreed through the pre-examination meeting for these procedures should be followed. Any movement from agreed deadlines does mean that the PLI process is at a risk of not running smoothly. And you all may have experience of that in the past. So reporters can ask questions or ask for more information using a procedure which we call further written submissions. So that's asking questions of parties and allowing others to respond to that. Another valuable way to narrow down the scope of any procedure is to use statements of agreement. You might have heard that term before. They're often used for issues like policy matters to focus down the key areas of dispute. These are generally regarded as a force for good because they allow the ability to clarify the matters that need to be rehearsed further. It's often the case that a counsel and the applicant will take the lead on a statement of agreement. Sinead's mentioned hearings and inquiry sessions. They're oral procedures that reporters may choose or agree with the parties. The hearing session, that's an oral procedure which is chaired and directed by the reporter, organised around a preset agenda, which is often agreed in advance, around which the reporter will ask questions of the parties and allow a discussion on each of those points that the reporter raises. The inquiry session is a more formal opportunity for parties to cross-examine each other's expert witnesses. And Sinead's mentioned that previously. However, we're starting to find that many topics can actually be dealt with by hearing sessions adequately. So our advice to the participants of the training today is not always to assume that a formal inquiry session is needed for all complex matters, and to consider in your position statement whether or not a hearing may be adequate for the reporters to get the evidence and test the evidence. In terms of site inspections, almost all cases require site inspections. Reporters will normally carry out most of the site inspections unaccompanied on their own. That's where access to private land is not required. Our guidance to you, I think, is to only request accompanied site visits if you think it's absolutely necessary. You may have had experience in the past of logistical challenges around getting 3 or 4 different parties together on site on a particular day, and invariably on that day the weather is poor and we have to reschedule. So unaccompanied site inspections are the most efficient for the process, and we're happy to be guided on that in terms of viewpoints or areas that parties want us to visit. But the preference in terms of an efficient process is unaccompanied. Reporters, on behalf of Scottish ministers, can also ask for additional information to add to the EIA report based on the EIA regulations that Simon touched on earlier. If the reporter does that, then it doesn't need to be advertised in terms of the EIA regulations if it's for the purpose of the inquiry. These occasions will generally be infrequent, however. And I think this has been mentioned earlier, that increasingly planning conditions are started a little bit earlier in the PLI process than in the past. Increasingly, reporters ask that planning conditions are discussed, drafted on the basis of the standard conditions with the relevant parties earlier on in the process. That is often done through further written submission procedures, first of all, and then lead to a focused hearing at the end of the process, normally only dealing with the key areas of dispute. And that often tends to be a shorter hearing process if we have gone through written submission processes earlier. So, not a very exciting topic now, but the documentation that you may all have been used to in a PLI is quite large. How it's managed and how all these documents are managed is very important to the efficient running of an inquiry. And we're producing new guidance on that, and that should be read alongside an existing guidance note, which is guidance note 23 about inquiries in general, but guidance note 23A, which will be published very soon. Apologies, it's not published quite yet, but we might be able to post that out with, well, email that out with any post-training correspondence that we do. But today I have been given authority to be able to tell you what's in it. In the past, you may have seen large master document lists, core document lists, used to be called. That's going to change slightly, because when the DPEA get a case from the ECU in the future that's going to PLI, we'll provide the applicant a template document list early on, and it'll be partially populated with links from the documents that we've received from the ECU. So we'll have done some work for the applicant. It will be split into two sections: foundation documents and supporting documents. And in summary, these foundation documents are going to be all the application documents and any documents that are to be relied on that are in our existing online DPEA libraries that some of you will have used. So the foundation documents are going to be application documents and from our libraries, and then the local authorities and other parties will be asked after the PEM to look at that foundation document list and agree it, and then it will be fixed shortly after the PEM and only added to in exceptional circumstances. Then the second part of the documentation is going to be called supporting documents. These are the documents such as hearing statements, inquiry reports and precognitions, all the documents that generally come after and leading up to the oral sessions or hearings and such like. We hope that those lists are relatively small in number, but all the supporting documents must be submitted at the same time as the hearing and inquiry statements that you'll have been used to submitting in the past during the inquiry. The applicant will then be asked to use those to create a supporting documents list. And it must be clear to the reporter why documents are required by all the parties. And the reporter will review the list of documents to make sure and may seek clarification from other parties on the relevance of documents. In terms of submitting documents, you'll possibly all know that the DPEA don't accept external links unless they're from our online libraries. So we will need that link to the libraries or an electronic version of the document. None of the foundation documents that I've just described will require to be submitted because they should have been submitted with the application or be hyperlinked to our DPEA libraries. So the submission of documents, of actual documents, of PDFs, will generally be for supporting documents only. Please only add documents that you wish to actually refer to at an inquiry or a hearing session, not just because you think it might be relevant. Only add it if it is relevant. When submitting documents, pay attention to the numbering guidance that we'll have given you. It might seem like a very minor point, but the numbering allows documents to run in the proper order on our case management files. If it's a really large document, you might have been given guidance in the past that just to submit the extract that is relevant, so no need to submit the whole document. If there's a part of a document, then that will suffice. On the matter of late documents, many might have had experience of inquiries in the past where documents appear very late in the process and during procedures. We want to try to get away from that. The default position will be that late documents will not be accepted unless there are exceptional reasons. So please avoid late documents throughout the process. All documentation should really be disclosed prior to all oral procedures and at the agreed deadline. So that's a discussion on documents. They are really important to the whole process. So that's why we've laboured those points. After all the procedures, the hearings, the inquiries, and towards the end of the inquiry as a whole, the reporter will ask for closing submissions and case summaries from the parties. This normally involves issues which have been dealt with by a hearing or an inquiry session. You won't necessarily be asked for a case summary for every topic or closing submissions on all topics. And this generally would be set out in the PEM note and then agreed by the reporter and the parties at the end of the formal inquiry or hearing processes. As you may be aware, the council and other parties, key agencies, will be asked to submit first, and then the applicant will be given the opportunity to submit their closing submissions and case summaries a couple of weeks later. Generally speaking, the submission of case summaries and closing submissions mark the end of the public local inquiry process. So we would ask that there are no more submissions after that, because we don't really want to reopen matters. In case you're wondering what a case summary is, that's a relatively new element to the PLI process. It's been going for a couple of years, but the case summary relates to a particular topic, and you'll be asked through a template to provide a summary of what you've rehearsed previously. So bear that in mind when you're preparing precognitions or authorising hearing statements, that at the end point will be a summarised version of that. It's to remain a standalone document or capable of being standalone, because we will be linking to it in terms of our end reports. But you don't need to worry too much about that today in terms of asking too many questions, because we'll provide you with a template which sets out the matters that the reporter wants you to deal with in the case summary. I think a couple of the presenters so far have mentioned inquiry report. Reporters aim to complete their report to ministers within 3 months of the close of the public inquiry. It's a very tight timescale, so it's important that all parties meet their deadlines in the closing submissions. You'll have picked up recently that we follow a fairly standard format in our reports, but the structure is specific to each case. We try to keep the wording succinct and use hyperlinks to evidence, including hyperlinks to the case summaries and closing submissions that I've just talked about. So the reports are not as long as they used to be in the past. The report focuses on the reporter's conclusions and their recommendations. We also include recommendations on proposed conditions, even when recommended for refusal cases. This is because ministers need to be advised of conditions and the implications of conditions if they are minded to grant consent. So that's why there's an early discussion on conditions. It doesn't mean we've come to a conclusion on the matter early on in the process. It's really that we need to be able to report to ministers on those matters. Once we complete our reports, they go off to the ECU. Although it's a report to ministers, it goes through to the ECU, and that's our job done as far as the DPEA and the reporter is concerned. And we hope that we don't have to reopen any inquiry for any reason.
So just moving on to the decision by the Scottish ministers. So the decision by the Scottish ministers needs to be considered in the realms of Schedule 9 of the Electricity Act, in terms of has the developer done what they reasonably can to protect the flora, fauna, natural beauty of the area and fisheries, and that's what that's what the cases hang on. There are obviously other material considerations, the development plan being one of them. In Electricity Act applications, the development plan does not have primacy, but it is one of a number of considerations alongside energy policy and the other matters that are raised through the application. To facilitate more consistent approach and to aid transparency in the process, again, as part of the onshore wind sector deal, decision framework letters, which set out basically a template for the decision letters, have been produced for onshore wind, but we're also moving on to those for battery energy storage systems and for the Section 37 priority applications as well. They will be published on the website in due course, and will help give a steer to people as to what to expect from decision letters moving forward. These have been based on recent decision letters that have been set out, but there's also some streamlining as well of those and updating of some of the guidance in them as well. So moving on to, in fact, just while I'm actually, no, we'll go for post-determination just now, and we'll come on to a few matters. So I've already mentioned judicial review. So that process ensures transparency, accountability, and fair review by any contested decisions on the energy infrastructure projects. It's the only route for applicants and third parties if they're dissatisfied with the decision of the Scottish ministers, and can only be sought by interested parties. This is usually limited to the applicant and any organisation, community group or member of the public who has engaged in that application process, but it's ultimately a matter for the courts to decide whether permission will be given for judicial review. And judicial review should be raised in the Court of Session within 12 weeks of the decision being issued, unless in extreme circumstances. It may be allowed to be longer than that. And then a judicial review assesses the legal validity of the decision-making process, focusing on whether the decision followed legal and procedural standards rather than reevaluating the merits of the decision itself. I think that's kind of key to note, that the court won't come to a view on whether the landscape and visual impacts or the ornithological impacts are appropriate. What it will come to a view on is whether those matters have been taken into consideration appropriately and in a reasonable fashion. So in terms of satisfaction and discharge of conditions, we covered this off in the question session earlier, so maybe we won't spend too much time on this. But the consent conditions would be part of Annex 2 of the decision notice, and those consent conditions, so the Section 36 consent conditions, they need to be addressed, and applicants need to submit those to ECU. With a number of those conditions, though, the planning authority also get notified and an opportunity to comment as well as part of the ECU's processes in considering whether to consider the condition satisfied and then ultimately discharged. And with deemed planning permission conditions, they would be submitted to the relevant planning authority for discharge. And we've covered off the standard conditions already, so we'll not dwell on those again. I noticed in the questions that there is a comment related to Section 36C, so I'll try and cover that off here as well. So Section 36C is an application for variation to a generating station only, but the Section 36C can incorporate changes to ancillary infrastructure and changes to the Section 36 conditions. So the question that was in the chat was, can a Section 36C be used to change the deemed planning permission? Applicants can request that the deemed planning permission is changed through Section 36C, but they don't always do so. At present, there is no variation rate for Section 37 consents, but that may change in the future. And for once the deemed planning permission is there, then for any changes to the conditions attached to the deemed planning permission, that would require a Section 42 application to the planning authority to make any deletions or variations of those conditions. When doing so, there is a direction that the ECU requires to be notified of any Section 42 on a deemed planning permission associated with a Section 36 consent. And it's very important to note that when a deemed planning permission is varied through the Section 42 route, that it shouldn't include the Section 36 conditions on the Section 42, because those conditions and the application, discharge and things like that of those conditions are matters for Scottish ministers, not matters for planning authority, so it would be considered ultra vires. And then in terms of ancillary developments coming forward related to the development that has been granted as deemed planning permission through the Section 36 process. So if, for example, there are new borrow pits required or a changed access track or something like that, they would all go through the town and country planning application process. There's usually a condition related to micrositing of ancillary infrastructure in the turbines, but sometimes the development is beyond those micrositing limits, and the planning application would be required. You can also, as a planning authority, move forward with non-material variations where it's appropriate. That's entirely within the gift of the planning authority. And then in terms of EIA, that's something that needs to be considered through any applications for ancillary development, but the guidance would be that it just generally needs to be proportionate in terms of considering whether EIA in the first instance is required, but secondly the scope of any EIA that may be required for any associated applications for ancillary developments.